So I thought we'd take a few minutes at the beginning today to review a couple of things that we talked about last week. And I wanted just to go over these. And now that I said that, what did I do with my notes? That's interesting. Here they are. Sorry about that. So, the first thing we talked about, you'll remember this inherent concept of inherent contempt. That is contempt of Congress. The witnesses who come before Congress and refuse to testify, as Mr. Bannon and a number of others have done. And the question of what rights Congress has and what rights the witnesses have. And there's no question that Congress has the power to investigate and the right to issue and enforce subpoenas. In fact, there is 2 U.S. Code Section 192 says a person summoned as a witness to testify and who fails to do so, this is in front of Congress, is guilty of a misdemeanor punishable by a fine of up to $100,000 and imprisonment for up to a year. Now, I don't typically watch these things, but I've not heard one senator or congressman refer to this section when a witness is sitting there saying, by the way, do you realize that? So, I don't know.
Does loss of memory count?
Well, everybody has that. Almost all witnesses.
Jeff Sessions said it.
Remember also that we talked about Congress has the right to go to court, civil court in D.C., to enforce, to issue a subpoena and enforce it. The problem with that is that it's time consuming. And there are several other problems with it. Even if the court issues the, says you must answer the subpoena, and the witness refuses to answer, the matter would then be referred to a U.S. attorney in the district for prosecution. What happens if the U.S. attorney doesn't want to do anything about that? There's such a thing as prosecutorial discretion. So, again, coming back to the political issue, if the U.S. attorney was appointed by or has some allegiance to somebody in the White House, then he or she may not be too enthusiastic about following this up. And, indeed, even if it goes to a grand jury, and the grand jury decides to indict, there's still a question of who is going to follow that up. So I think as a practical matter, these are interesting questions, but it's difficult for the Congress if the White House doesn't want to play. It's difficult for the Congress to follow through. George?
The witness does have, you know what to call it, the right to refuse to respond if it may incriminate himself. He's got a constitutional right for that.
Well, he has, but the question, it depends on what the questions that are being asked. So the fact is that before Congress, yes, you can say that, but as I say, the court can issue a subpoena to have you come and testify, and if you continue to say that, you can be held in contempt. Yes, Jim.
How does executive privilege fit into all that, though? I worked at the White House.
Well, I want to talk about that. We're going to talk about the Nixon cases, and we'll get to that specific question when we get there. I think that's a very good question and a very important one. So, who remembers the name Ann Burford? Is that a name that's familiar to anybody? What about if I said Ann Burford Gorsuch? Yes. Anybody remember that name? Well, that is the mother of our new Supreme Court Justice, who was appointed by President Reagan as the administrator of the EPA back in 1982. And she came before Congress and was held in contempt. She was asked to produce documents, which she did not produce. She was unwilling to produce. She was held in contempt, and there was a long history of events. She wound up resigning as the EPA administrator. Reagan offered her a non-paying position with something to do with oceanics and space, which she declined, and she went back to Colorado. But in any event, that was the first time that the name that I had ever seen the name Gorsuch, and it took me a while to make the connection when it reappeared not too long ago. It's also interesting to note that there is a law on the books that the Senate has specific legal authority to secure a declaratory judgment in court. There's a law that's been passed that says they can go to court and get a declaratory judgment against a witness. The House does not have that specific authority. They need a full resolution of the House, the majority of the House, in order to go to court to get a declaratory judgment. So remember we talked about the Myers case last week, Harriet Myers. I've just mentioned the Burford case, and I think we also talked about the Holder matter, Eric Holder, who was also held in contempt by Congress. So although the courts have upheld Congress's authority to issue and enforce subpoenas, the efforts to punish an executive branch official, or maybe a former official, are likely to prove unavailing. History suggests that the Department of Justice is not going to prosecute these people for reasons that I think obviously relate to politics. Using a declaratory civil action always involves a protracted appeal process. The Myers case was dismissed after 19 months in the federal court system. So 19 months, actually, the administration was over, she was gone, and we come back to the politics of the issue. I think that's the underlying message. And the question, I think, is always, and it is today, with the House and Senate Judiciary Committees, how serious are these committees committed to getting this effort accomplished? And I think, again, we don't know what will happen in the 2018 elections, but if the Democrats are to make a significant inroad into the House and take over the Senate, we might see a change or a shift if this stuff is still going on, which at least it's conceivable that it may be. But it requires a significant effort on the part of the committee. Remember, we also talked about the practical things that Congress could do. You know, if somebody was an employee and refused to answer, theoretically Congress could zero out their salary. We're not going to pay these guys, or this guy, or this gal. They could do that. Now, it hasn't been done, but it's something that, that's typically, not typically, that is actually something that they could do. And we talked about other, perhaps more even elaborate things that they could do, but in general, they've chosen not to go forward on that basis. So, moving on, executive privilege. Jim brought this up. This is really another one of these complex dilemmas. It's balancing the public need for information with the need for the executive branch to fulfill its responsibilities. Does secrecy threaten the liberties guaranteed by the Bill of Rights? So Article 1, Section 5 of the Constitution says, is this Article 1 or Article 2? I think it's Article 2. But Article 1, whoop, where are you? There you are. So, 3. So this says, each house shall keep a journal of its proceedings, and from time to time publish the same. This is the congressional record, excepting such parts as may in their judgment require secrecy. Now, there is no such provision in the executive section of the Constitution. And some academics and Constitution experts have argued that because this does not appear in Article 1, I'm sorry, in Article 2, that it basically means that the founders did not intend for the executive to have secret proceedings, and that executive privilege, quote unquote, remember that word was not coined until President Eisenhower, was not contemplated by then. You may or may not agree with that. And then the other thing is that this also says, the Constitution also says that the President shall make periodic reports to the Congress, a la the State of the Union address, which we will be hearing about in a very short time. And again, there are Constitution experts who say the fact that the President has to report to Congress is further evidence that this flow of information is required in one way or another. When FDR was president, particularly, well, when he was president, one of the methods he used to communicate with Congress was bringing small groups of congressmen to the White House at various times to talk about a specific issue or issues. Early on, of course, it was because of the New Deal legislation, but later on, while the war was going on, he brought people in to provide information to a small group of senators and congressmen about what was happening. That was his way of communicating to key people in the Congress about what was going on. So that's another way that this may be affected. But then there have been a number of Supreme Court cases which have stated that the President has the right to protect privileged information, but this does not override the authority of the judiciary to review the protected documents. And the last thing I wanted to mention, because I think it's become quite important, is we now have FOIA, the Freedom of Information Act, which allows citizens and groups to request information from various government agencies. And this material has become extremely important, this process and procedure. And what the court does here is to balance the competing interests on a case-by-case basis to evaluate the relevance of the evidence, the seriousness of the litigation, the harm or possible harm from the disclosure, the public interest, any government misconduct that might be apparent. So that's another way in which those items can be discussed. Lastly, there were a number of questions about the grand jury, which we briefly talked about in the last session. And I wanted just quickly to run over a couple of points that may or may not have been clear. One, the presentment or indictment of a grand jury is under the Fifth Amendment. You may or may not be aware that in the early days, private citizens could bring an action before the grand jury. And it's only the development of public prosecutors in the last 100 years, less actually, which has basically eliminated that. Private prosecutions under the grand jury system, for all practical purposes, don't exist. We talked about secrecy in the grand jury proceeding. There's no judge, there's the prosecutor, there's the defendant, and there's the jury. And that's it. In fact, the defendant may not even be there. The defendant may not be aware that an indictment is forthcoming. That's up to the prosecutor. So in some cases, the defendant or potential defendant is not there. There's a transcription of the events, but the transcript is sealed and is not available. The jurors are able to ask questions of the defendant or indeed of the prosecutor. So that's another byplay here that you would not see, of course, in an ordinary jury trial. In some places there are special grand juries that have been put together for organized crime activities. New York has had one, more than one, and that they have existed in other cities. The jury makeup is usually 16 to 23 people. An indictment is usually required 2/3 or 3/4. People get $40 a day, I think is the current rate. After 45 days, they get $50 a day. They are not screened for makeup or bias. It's just a question of facts. So it is true that the prosecutor has a big edge here, and there has been some discussion in various places about trying to bring in reforms into the system. And that's a continuing effort. If the defendant has been identified, he can have a lawyer outside of the room, and he can ask for a recess to go consult with his lawyer, but his lawyer cannot be inside of the room. And you need probable cause in order to indict. Yes?
Does a U.S. judge, district judge, preside over a grand jury?
No, there is no judge. There is no judge. It's just the prosecutor. Right. Right.
And if the defendant can walk out of the grand jury after each question to ask his attorney what to do and then walk back in.
Thank you. Bob?
Yeah, back to the question of executive privilege.
Yes.
It was concern because there has been privilege requested prior to the incorporation of the president. In other words, the swearing in of the president. There are 3 sections of time. There's the time prior to the election. There's a time between the election and the swearing in, and then of course there's a time after swearing in. And the question of executive privilege, as I understand it, in some of these situations, is that they are declaring it in times when he was not sworn in as the president. So he didn't have executive privilege.
So did you see what's on the board underneath this screen? We're going to come to that very point. Thank you. Yes.
Going back, you said that the jurors are not screened for bias. It's all a matter of the facts. Who gets to determine what the facts?
Well, that's a fair question. And you know, the answer is that the prosecutor gets to determine what the facts are. Now, it has to, obviously, that's just the beginning of the process. And you know, you now have to bring an indictment. You have to, you know, so. But that's the way the system has been. And to that point, as I say, there are some people who feel that this process is badly, you know, badly driven here and should be reformed.
There's a common expression that a prosecutor can get a grand jury to indict a ham sandwich.
Yeah. So lastly, in terms of kind of review, remember we talked about the Myers case. We spent some time on it last session. That was the case where the postmaster in Oregon was fired by President Wilson. And we had that case where Chief Justice Taft ruled that the president could fire anybody even if they had, excuse me, required senatorial approval for their appointment. And so this minor personnel flap, which took place back in the 20s, you know, you'll remember that Wilson became seriously ill, and his wife basically was acting as president for the last couple of years, a year and a half of his term. But in this particular case, several interesting things happened. One was that Myers died while this litigation was going on. His wife took over the litigation, and then Taft really wrote this opinion, which was much wider than it needed to be in order to kind of handle the situation. And this has become, quote unquote, basically kind of the law of the land. There was a case not all that long ago called Morrison v. Olson, where Rehnquist wrote the opinion, which upheld removal procedures for the Independent Counsel Act. And that case never even referred to Morrison v. Olson, and Scalia wrote what I call an apoplectic dissent in this case. He was absolutely, obviously furious, and basically said that you know, this was preposterous, and referenced Myers. So this Myers case, which is still on the books, may still be something that we're going to need to contend with going forward. So I'd like to move now, and you've already really brought us kind of to this point, to the four Nixon cases. There are actually more than four, but the four really important ones. And we have here U.S. versus Nixon in '74, Nixon versus the GSA in '77, Nixon versus Fitzgerald in '82, Nixon v. Warner Communications in '78. Bob, we've got the well, first we have public, private, official, unofficial, and then we have timeline, prior to election, election to inauguration, and post-presidency. There's your timeline. So what, you know, are these matters that are so important? And of course they relate to executive privilege. So the basic question in this first case, the 1974 case, was the question of executive privilege. The grand jury in D.C. indicted named individuals. There were various offenses, including conspiracy to defraud the United States, obstruction of justice, and Mr. Nixon was famously named as an unindicted co-conspirator, whatever that may mean. The district court issued a subpoena to produce the tapes and documents for use in a pending criminal trial. And then in the Supreme Court, Nixon moved to quash the subpoena on grounds that materials were within his privilege against disclosure of confidential information. You may or may not remember that the lawyer who argued the case for Mr. Nixon was Jim St. Clair, who was out of Boston, and one of his great lines was, this is in front of the Supreme Court, he said, "The president wants me to tell you that he is as powerful as Louis XIV, 4 years at a time, not subject to the processes of any court in the land except the court of impeachment." I wonder how that sat with the justices. So, and then, of course, famously, the Supreme Court said that it was the duty of the Supreme Court to say what the law is with respect to the presidential claim of executive privilege, citing Marbury versus Madison, a famous constitutional case back in 1807. And they said the president did have a privilege, but it wasn't an absolute privilege. And that neither the separation of powers nor the need for confidentiality without more can sustain an absolute unqualified privilege. Absent a claim of need to protect military, diplomatic, or sensitive national security secrets. The integrity of the judicial system depends upon full disclosure. Production of evidence is needed either by the prosecution or the defense, and the fundamental demands of due process of law in the fair administration of criminal justice. Not all the tapes were beyond confidentiality, and they needed the greatest protection consistent with the administration of justice. The court never ruled on the question of whether the president could be named as an unindicted co-conspirator. They basically punted that question. Then later, in Jones v. Clinton, another famous case in this regard, there was a question of whether a president could be held in criminal contempt of court and subjected to criminal penalties, which raised constitutional questions which the court also punted on. They never answered that question. They talked in Jones v. Clinton about a civil case. So So that was basically Nixon. This case is basically remembered for, yes, there's a privilege, but it's qualified. And I think that, I mean, obviously it was more complex than that, but that was, for our purposes, I think that's the important point. Now,
who made the decision as to whether those tapes fell into those specific categories that were excluded?
well, Sirica had originally looked at those tapes, the lower court judge, and basically what the court said was that Nixon had to hand over, there were specific tapes that they were trying to get. That was the famous tape that Rosemary Woods had put her foot on the whatever, and 7 minutes or 12 minutes or whatever it was, 8, thank you, had disappeared. So there were specific tapes, and it was those specific tapes that this was about.
Maynard, wasn't Nixon on the David Frost show, and he said a president cannot break the law?
Well, words to that effect.
Use words to that effect. I can't break the law, I'm the president.
Which we're hearing.
So I think we have, yes, I think there are other presidents who may have made similar comments. So this next case, I think you may or may not be familiar with. When Ford was president, he signed into law the Presidential Recordings and Materials Preservation Act. This was an act that was designed to protect all of Nixon's papers, all of the documents that he had been responsible for while he was president. And Nixon brought a suit in the District Court of D.C. to challenge the constitutionality of this act. What this act provided was that the GSA, the General Services Administration, would take custody of Nixon's papers and promulgate regulations for access to them, subject to screening by government archivists before they were returned to Mr. Nixon. And Nixon appealed the ruling, and SCOTUS, the Supreme Court, voted 7-2 to uphold the ruling. It's interesting. Who were the two justices who voted against this decision? Berger and Rehnquist, who both served as Chief Justice at different times. Basically, the court said the control of the materials remained in the executive branch because the GSA is part of the executive branch, that there was a limited intrusion into the executive confidentiality justified by the Congress's need to preserve an accurate historical record, that there was no violation of the Fourth Amendment, search and seizures, that he, as president, he was a public person and had no expectation of privacy. An interesting phrase. No violation of the First Amendment and not a bill of attainder, which would be an act passed after the fact, which they also argue. So that was with regard to his records. Then we come to the Nixon v. Fitzgerald case, which was actually a very interesting case. This was a case of a guy named Fitzgerald who worked for the Air Force, who before Nixon became president testified to Congress about fraud and waste and mismanagement in the Department of Defense. Basically, he was a whistleblower. And after Nixon became president, this guy was fired. And he sued the he sued the Air Force, the Department of Defense, and a whole bunch of people. And then later in the suit, he added Nixon to the suit because he believed, and I think there's some reason to believe, that Nixon himself had been involved in saying, as some other presidents, I think, maybe, fire that guy. So he loses his job, he brings this suit, and the D.C. court held that he had a triable action. The Court of Appeals said no. The president is absolutely immune from damages or any liability predicated on his official acts as president. Absolutely immune. And they went on to say, as courts often do, this extends to all acts within the outer perimeter of the president's official immunity. Wow. There's a law school question. The outer perimeter of the president's official immunity. This applies to private suits for damages based on official acts. So we have a private suit here based on official acts. And actually, remember, the act of Fitzgerald, his firing, took place prior to the election. Nixon actually came in and he was actually fired after the election. But so this is, again, actually, interestingly enough, in this case, it came to light. There was a sidebar here. Fitzgerald had come to a settlement agreement with the Air Force for $140,000, which at the time it was signed, nobody knew about. And there was a clause in the document that said the $140,000 would be reduced to $28,000 if the Supreme Court decision upheld Nixon's immunity. Now that really is my view is that's way off base. And, but the court, which I think knew about this, basically ignored it. But I think the important clause here is, yes, the president is absolutely immune for anything he does officially. Remember one of the things we asked last week, are these tweets official business in any sense of the word? If he said, Jones and Smith, are nasty people, and, what's more, they're whatever. He libels them. Is that an official act, and could he be sued for libel? Could the president be sued for libel? That's a nice question. If the president can be sued for libel, we might have a lot of suitors lining up here before. So 15 years later, in 1997, in the Clinton v. Jones case, the court ruled that even an incumbent president does not have immunity from lawsuits by individuals for acts committed before he assumed office. So that's part of this time factor thing, Bob. Before he assumed office. And that was a unanimous decision. Now, I want to give you a very, I actually didn't know about this case. I came upon it. In 1962, President Kennedy was standing, 1960, he was standing outside the LA Convention Center at the Democratic Convention. And it was during the heat of the convention, in the middle of it, and there were a group of delegates from Mississippi who were standing in front of the convention, and they were trying to get a ride to go to an event for delegates that was being thrown by Pearl Mester. You remember that name? The hostess with the mostest. And they couldn't get a ride. And Kennedy had hired a car, a limousine, for his personal use. And he said to them, because he saw that they couldn't get a car, "Where are you going?" They said, "Well, we're going over to the party, but we can't get a ride." And he said, "Take my car." He had the driver. So these people get into the car, and they go along, and they get into an automobile accident. And one of the people who got into the car, I forget his name, I've got it written down, but he was a state senator in Mississippi. And he used to run on the title, I'm not making this up, Senator on a Donkey. And after the automobile accident, he was injured. and he claimed he couldn't get back up on a donkey anymore, and therefore he brought an action against Jack Kennedy. Now, Jack Kennedy didn't drive the car. He wasn't paid for anything. This was a gesture that he made. And so how did this turn out? Well, the senator on a donkey, these people hired a lawyer in Los Angeles whose name was Marvin Mitchelson. Do you remember that name? Well, Marvin Mitchelson was the famous palimony guy who brought that action on behalf of the gal who was living with Lee Marvin. And palimony, which is now legal in 25 states. It's not, I'm told, legal in New Hampshire. And, I don't know how many of you remember, that gal actually wound up getting nothing. But it made Mitchelson famous. This is before all of that took place. So, a senator on a donkey brought an action in the district court in Los Angeles. And the judge first ruled that the president could be sued because this was an event that had taken place prior to his election. A civil case prior to his election. And in the proceedings, the court ruled that Kennedy was guilty. Not guilty. That, in fact, that this guy had an actionable suit. And Kennedy wound up paying him $17,000. So, you know, anything is possible.
So that's the definition of no good deed goes
Punished.
Senator on a horse. So, on a donkey, right, on a donkey. So, let's move on then to the last one, which is, well, I want to say one other thing about this Fitzgerald case, because I think this is important. The court said that a rule of absolute immunity for the president will not leave the nation without sufficient protection against misconduct by the CEO. And they cited, these are things that are presumably sufficient protection: impeachment, press scrutiny, vigilant oversight by Congress, desire for re-election, the need to maintain prestige, and a historical concern for stature. Whoa. This decision was 5-4. And the dissenters were White, Brennan, Blackmun, and Marshall. So there were a number of liberals who felt that this was inappropriate. But that was the decision. Blackmun said in his dissent, quote unquote, "No man, not even the president, is above the law." Well, we're going to talk on Thursday about the rule of law, and we're going to talk later today about impeachment. But this is the beginning of these kinds of conversations. The court went on to say that it was not conceivable that there would be a series of events by a particular president that would, kind of recycle back on these issues. So that brings us to the last one, which is the Nixon v. Warner Communications case. And this, I think, is an interesting case, perhaps the least well known. Well, before I get there was a companion case to the Fitzgerald case, which was Harlow v. Fitzgerald, which was another suit. And I think this is important because the court here distinguished. This was a case where the court distinguished a qualified immunity to executive officials, balancing competing values versus damages to protecting citizens' rights. So basically what they said, the court has said, even though there are government officials whose special functions or constitutional status require complete protection, that does not apply to people in the White House. Does not apply to people in the White House. It would apply to the Secretary of Defense or cabinet officials, but it would not apply, they said, to, because these are not constitutional status positions. And they went on to say that public policy does not require a blanket recognition of absolute immunity for the aides to the president. So this is all interesting information. It probably would be considered dicta, which means it's not necessarily precedent, but it is language that might be used, or maybe I would say will be used. It's only a question of when. We're going to hear some of these cases come back. So before the break, let me just spend a couple of minutes on this Warner case. I think it's also interesting. This is a case where Warner Communications wanted to release all of the tapes and all of the testimony with regard to Watergate. And it's quite interesting because 22 hours of tapes were made available to the jury and the public in courtrooms. There were reels of the tapes that had been introduced into evidence. And there were 4 people who were convicted. And anyway, Warner wanted to sell this material.
Broadcasting or sell them?
Both. And the court said that the common law right of access to judicial records did not authorize the release of the tapes in question from the district court custody. And basically, they said that they reversed the decision. They said that they could not, in fact, sell these tapes and at that time. So that was kind of an interesting byplay to this situation. So coming back here for a moment, this question that Bob raised, we have a whole series of issues based on whether the act, first of all, we have the president, then we have elected, we have appointed officials to cabinet positions. Then the court has created another category of people, quote unquote, aides to the president, whoever they may be. And we have public v. private, we have official v. unofficial. We have this time frame. When the event happens or when the event takes place, is it prior to election? Is it between the election and the inauguration, between November 6th or 8th and January 20th, or is it after the inauguration? And I'm going to give you another one because we mentioned it last week. What about post-presidency? Can we have an impeachment or an indictment based on acts that were committed during his term after the election? So we'll talk about that after the break. Let's take that. I'd like to spend a little time talking about emoluments and then move on to impeachment, a famous topic. Emoluments is one of these odd topics that has developed, as you may know, into some significance in the last, whatever year, maybe even before that, because of the feeling that, on the part of many people, that Mr. Trump's business entities and the web of involvement, business involvement that he has around the country and indeed around the world is a violation of the Emoluments Clause. Well, it turns out that actually there isn't one Emoluments Clause. There are 3 Emoluments Clauses in the Constitution. And
Maynard, you have to push the other one.
oh, yeah, I guess that's a good idea. Thank you. So, what do we mean by emoluments? And so in doing, you go to the dictionary. This is a word that goes back a couple of hundred years in the English language, and it comes from a Latin word, emolumentum, I think, which basically means gain or profit. And it was used in the parliamentary sense in England and carried over. But basically, I mean, the court, there haven't been a lot of cases on this. There have been some. But this is one of these times when I think, I wonder about lawyers. They go to all this trouble to try and explain what this means. And to me, it's pretty simple. It's a benefit. I mean, I don't know why they're tying themselves up in knots, but they have been. And so if there's a benefit, and interestingly enough, the Emoluments Clause applies. There's one that applies to the president. There's one, this one, which is the Ineligibility Clause, which is here in Section 6. Here we go, which says, no senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof have been increased during such time. So what does that mean? Well, in 1937, Hugo Black was a senator from Alabama, and he was nominated to be on the Supreme Court of the United States. And during the time that he had been in the Senate, there was a vote to increase the pension for Supreme Court justices. And so this became a dispute. And actually, what is interesting when you really look at it is, it didn't increase the pension of Supreme Court justices. The bill simply said that their pension couldn't be diminished. So it didn't promise anything, except you couldn't get less than you were now getting. And this case was, and at that time, Black would have had to wait 19 years before he was even eligible for this. He was only 51 at the time. And so this suit was brought. And the Supreme Court ruled in all its majesty that the petitioner lacked standing to bring the suit. I don't even know who the petitioner was, but whoever it was, they threw it out. So he became a justice, and that was the end of the discussion. Then there was a more famous, better-known case. Bill Saxby, who was an Ohio senator, was appointed Attorney General by Nixon after the Saturday Night Massacre. Remember, the whole department was decimated, and he appointed Bill Saxby as AG. And this was in the first year. In the first year of this term, there was a salary increase for cabinet officers, and this was in '73. So Nixon reduced Saxby's salary to what it had been in '71 before he voted on an increase in what, of course, he had no way of knowing would be an increase in his own salary. That became known as the Saxby fix in political parlance, and has been used by a number of other presidents when they have appointed a rep or a senator to some position. Clinton used it when he appointed Richardson as ambassador to the United Nations. He used it when he appointed Bill Cohen as the Secretary of Defense. When Hillary Clinton became Secretary of State, she had been in the Senate, and her salary was set back to what it had been when she was elected to the Senate.
What about
Question,
Mike?
Does the president set salaries? I thought Congress.
No. The president doesn't set salaries, but he had the, well, he's the president. He had the authority to reduce her salary. He couldn't have increased it, but because only Congress can appropriate, but he can decrease salaries. He could say, you can only serve if you will receive X. Fair question. So there's been virtually, I haven't been able to find any discussion of this clause anywhere. And it's, there have only been 2 suits. They've both been dismissed for a lack of standing. But anyway, that's with regard to this so-called ineligibility clause. Then there's, yes.
Excuse me, have there been any suits filed against Trump that are winding their way through the court, or is that still?
They have, but I'll get to that. So if we go to, yes, the answer to that is yes. So if we go to Section 9, hello, Section 9, Clause 8, I think, if I can find it. 2, 4, 6, 7. Oh, yes. So here's this famous clause. No title of nobility shall be granted by the United States, and no person holding any office or profit of trust shall, without the consent of Congress, except of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. Foreign state. So, with regard to this, there are several words here that have caused interesting debate. One of these is, what is a foreign state? I think I sent you an email. Did I send you the Nobel Prize one, or did I send you the Reagan one? Anyway, both. So if you took a look at those, I mean, a memo 13 pages long, I think, to show that Obama's accepting the Nobel Prize was not an emolument, and they also said was not from a foreign state. 13 pages on that. When 2 former presidents have received the Nobel Prize, a former Secretary of State, whilst 2 former Secretaries of State, while being in office, as well as a number of other people. So, again, and then the one on Reagan was equally, I think, interesting, because that was about whether or not he could accept his retirement pension from the state of California. I mean, how preposterous is this? Truly, how preposterous is this? And now we have a situation where, you know, who knows how much money is floating, you know, or not floating, back and forth, We have a situation where the Secret Service is renting space from, you know, the Trump Tower in New York. We have dozens of situations where there are direct payments that are being made from the federal government to Trump-held entities. They're all over the place. And yet, we have, you know, who's concerned about this? Well, you know, there was a question asked over here. Are there any lawsuits working their way through the courts? Well, in fact, there have been a couple of lawsuits working their way through the courts. There was a lawsuit brought by an organization called CREW, Citizens for Responsible, I don't know, Ethics and whatever. And that was a group of lawyers, including a couple of the former president's ethics counsel. That guy who appears on television who worked for Bush, and thank you, and another guy, and then they got together a couple of restaurateurs in D.C. to bring this action. And basically, the premise was, you know, this business at the Trump Hotel in D.C. is costing us business. And the court has thrown that case out. They have said that basically they've come back to that famous comment, you don't have standing. Now, there are two other cases that actually were joined by the district attorneys, the U.S. attorneys in D.C., the attorneys general in D.C. and in the state of Maryland, which have been brought against the Trump organization, which are still, they're really just beginning. The most recent action that I'm aware of was in November when that district court judge said they could subpoena records from the Trump businesses which were involved. And I haven't seen anything since. But that was a pretty interesting ruling. I suspect they don't want to submit these records. You know, one of the things they've said all along was, you know, they were going to donate all the profits to charity, which is one of Mr. Trump's famous lines. And he was going to donate his salary to charity. We saw the very first monthly check, I think, to some organization, but there have been 12 since, and I haven't seen any further checks. And I wonder what's happened to that. Yes.
I have a question. Forgetting the competition issue, which I understand.
Yes.
Just the fact that our government employees are staying at a place where the president makes money would seem to me, isn't that a conflict of interest?
Well, I leave it to you.
Then there's the management versus ownership, which... Yeah.
Right, well, yes, there's a management versus ownership. But I think, you know, the point here is, to me, I mean, this is kind of a common sense issue. Now, the other side is, and I think there are a lot of people who say this, what difference does it make? And I guess, on the one hand, it doesn't, the difference it makes is this part of an ethical pattern of behavior? Would we be saving money, would the government be saving money, if they were staying elsewhere or making payments elsewhere? And I think, you know, this is arguable. I'm not here to sell you the answer to the question, but I am here to say that if you go back in our history to the very beginning, when Ben Franklin accepted a snuff box from Louis XVI to literally to, I forget which, I think one of the presidents accepted a horse from the King of Spain, and every one of these things all the way through, all the presidents, all basically ask the question, can I accept this? Where does it go? Many of these things, I don't think the horse, but many of these things appear in the Library of Congress or, other places where it's been put for the public to see. So why is it that we're now here and, we have so much trouble with this? Jack Kennedy, when he was president, got a ruling with regard to his pension disability pay from the Navy. And they ruled that he couldn't receive it because he had already been paid for his service to the date that he was injured. Now, I don't want to go there, but that doesn't make a lot of sense to me. But in any event, he did not receive any disability pay because of that emoluments clause. Yes, Dave.
But the issue here with Trump is, at least the argument, is that the foreign dignitaries or countries that want to curry favor with the administration are essentially contributing bribes by renting rooms in the International Hotel in Washington, Saudis.
I would disagree with one thing you said. I don't think the issue is that they're giving bribes. I think the issue is, and again, this depends on how you define these terms. The emolument is a benefit. That doesn't mean it's a bribe. There is also a Foreign Gift Act that basically says that, you're not supposed to accept any gifts. And there is a case, a Supreme Court case that's, 130 or 40 years old, that basically says that an emolument is only what you're entitled to, i.e. your salary, etc., and that a gift is not an emolument. And that a business transaction is, now that is not an emolument. Now that's a single case.
Franklin and his snuff box.
Right.
That's a gift.
Yes, that is a gift, but there was no legislation at that time. There was no act. That's a very recent act. So I think, and it's, again, I think it's a debatable matter. Again, I'm not selling one side or the other. The other issue is, what's a foreign state? If you get a benefit from a bank in the Soviet Union that's lending you $1 billion, pick a number, at a special rate, is that from a foreign state? Well, I don't know. There are only a few banks in the Soviet Union that could lend that kind of money. And, Putin is a shareholder, if not, in each one of these. Is that from a state? We could argue that case all day long. But I think there's reason to believe that it might be. And the next question is, who has standing to bring that suit? If the restaurateur can't bring it in D.C., or the owner of a competing hotel, who can bring this suit? Well, as I say, we now have a suit in between the AGs of the D.C. and Maryland. I don't know where that will go. It may not go anywhere. So, who can bring the suit? The federal government could bring a suit. Which branch? Well, I don't know. Who's going to bring a suit in the federal government against the president now? I think the answer to that is nobody. It's not going to happen. A state can bring a suit. We now have 2 states that are bringing a suit. Will that go anywhere? I have no idea. Individuals can't bring suits. Could the media bring a suit? I don't know. But these are, what I like to say is, geez, I've got some terrific questions, but I don't have the answers. So, you know, I think this is one of those situations where there's some interesting questions, but the answers are a little hard to come by. And maybe, I mean, I think what we've seen is we've seen a move away from, you know, a lot of fussing about this. There are some people who are constitutional scholars who are still fussing about emoluments and concerned about them. I think my own personal opinion is that if you follow the money, if Mueller's given the time and the resources to follow the money, they'll find some things that have nothing to do with emoluments that have to do with more serious crimes. But I don't know that, and they haven't done it yet. John?
Isn't this really an issue of ethics and the frustration on the part of so many people that Trump is in this for himself as opposed to the country as a whole? I mean, that's the one side argument, and that therefore these are examples of what he is doing to foster his businesses or whatever, and when he gets out, that is what is there.
I think that's one side of the discussion.
And that's, if there is, in terms of actual action that can be taking place, it's highly, you know, unlikely. But, except maybe these two states. But it's really an example of the frustration on the part of so many people that he seems to be doing things that are good for him and not.
Any further comments on this? So, yes, Bob.
Just, you raised it, and you're probably going to get to it, but if Mueller does uncover, just in the course of his charge, crimes that were committed prior to Trump ever even being in the political arena, that would otherwise be indictable because they're serious enough and the evidence is clear enough, can he be indicted, or is he going to have to get impeached, or does it just...
Well, we're actually going to talk about that very specific question. I think, however, the short answer to your question is that if these were things that were committed prior to his election, he can absolutely be indicted. The question is when. Can he be indicted as a sitting president, or do you have to wait until his term is over? That is a question which has not been answered.
It's being asked, though.
It is definitely being asked, and constitutional scholars are all over this on both sides, and we'll talk in more detail about it.
Well, so the other thing that you reminded me about as you were speaking, can he pardon himself for a crime?
We're going to talk about that on Thursday.
A crime that preceded his office.
You never know until you try. Barbara?
Slightly different issue, but isn't it illegal for the president to be renting a government building?
That was another one.
Well, I think that's another, you know, I think that's another subset of this question. You're talking about the post office? Yeah, and the hotel. Right. Well, he wasn't president when the deal was done. You know, he said he was going to, recuse himself. He's not recused. The kids don't walk around the corner without talking to him. So, you know. So, let me move on here. I think that you've raised some very interesting questions, and around a fireplace with a couple of hot toddies, you can have some very interesting discussions. So I'd like to move on to this interesting question of impeachment and where we are with that, or where we go. First, I'd like to make a couple of comments that I think are important before we start. There are two long-settled propositions that it's important for us to understand. When the president takes official action, the court has authority to determine if he has acted within the law. I don't know if you remember when Harry Truman seized the steel mills in the late 40s, and it was a huge fuss, and the Supreme Court said he did not have the authority to take over the steel mills. And so that was an example where he took an official action and the court said, you can't do it. So that's Proposition 1. Proposition 2, the president is subject to judicial process in appropriate circumstances. A, Chief Justice Marshall directed, this goes back to the early 1800s, that a subpoena could be directed to the president. This was a case that involved Vice President Burr after he killed Alexander Hamilton. And remember, he was vice president at the time. And there was a big question about whether the vice president could be served a subpoena. And the court ruled he could be subject, it could be directed to the president, to the vice president. And then the court agreed in the Nixon case. They basically endorsed that by saying that Nixon was obligated to comply with a subpoena commending him to produce certain tapes. Not all the tapes, but certain tapes. However, again, there is no absolute, unqualified presidential privilege of immunity from judicial process under all circumstances. Now, examples. Ford was deposed in a criminal trial. Had nothing to do with his committing a crime, but he was deposed in a criminal trial. Clinton was videotaped twice from the White House on testimony in criminal proceedings before the grand jury. So he was sitting in the White House, the grand jury was across town, and he was videotaped. My guess is that if Trump is subpoenaed by Mueller, that's likely what would happen. That he would be videotaped from the White House, or maybe from Mar-a-Lago for what I know, the 8th T, while testifying. Carter was videotaped as a witness in a criminal trial that had nothing to do with him. And Grant gave a lengthy deposition in a criminal trial back when he was president. During Iran-Contra, Reagan testified on videotape, and basically he said, I don't remember. And Bush and Cheney testified before the 9/11 Commission. So presidents have testified in criminal activities, and I think that we need to remember that. So I think what we need to start with when we talk about impeachment is this wonderful term, high crimes and misdemeanors. That sounds like a Gilbert and Sullivan kind of term. I think I don't know. And this is 400 years of English history, going way back to the 1300s. And it has a special meaning. It's not the word that we understood, that we understand to be a misdemeanor. I think when we talk about misdemeanors, we think of it in relationship to felonies, which are, quote unquote, more important or more substantial than a misdemeanor. But that's not at all what the English history had to do with. And basically, what this phrase means is subverting the government, or the crown, as the English took it. High crimes and misdemeanors, damage to the state. Examples, this comes out of a couple of things. This is not limited to traditional crimes. Misapplication of funds, abuse of power, neglect of duty, betrayal of trust, encroachment on Parliament's prerogatives. It's confined, this phrase, I don't think you'll find it anywhere else, except in parliamentary impeachments. It's not used in the ordinary criminal law. And so I think that's the first thing we need to know. And in the Federalist, which of course is the debates around the Constitution, there was a big discussion about whether there was going to be a president, a singular executive, or a council of people. And as we all know, they decided on an executive. And I think Ben Franklin had a wonderful phrase. He said, impeachment would be necessary when the president has rendered himself obnoxious. I don't know why, I don't know why Chuck Schumer hasn't picked that up. Bob?
Just as for my own benefit, is there a distinction between a high crime and a misdemeanor?
No. It's basically together. Okay. It's a phrase. Right. So there are three major constitutional duties that the president has, and they're all constitutional. The first one is to take care that the laws are faithfully executed. This is in his oath that he swears when the Chief Justice, in front of the Capitol there at the inauguration, to take care that the laws are faithfully executed. He has the responsibility for the overall conduct of the executive branch with broad discretion, but presumably some limitations. Then he has to faithfully execute the office of President of the United States, presumably to be diligent and in good faith. And lastly, also in the oath, to preserve, protect, and defend the Constitution of the United States. This is a duty not to violate the rights of citizens, nor to act in the derogation of powers. Basically, the Constitution and the American people entrust to the President the singular responsibility for the rule of law, which we'll be talking about on Thursday. So, perjury, the obstruction of justice, strike at the heart of the rule of law, and I think that the wording, those words that come directly out of the Constitution, two sets come out of his oath. Those are the things, if, as, and when the president were ever impeached, I think you would see those words being at the top of the list. Now, I think I mentioned in the last class, there have been 19 impeachments in our history. 17 of them have been federal judges, and 2, of course, Clinton and Johnson. But there's an interesting one, the impeachment of Judge Walter Nixon, no relation, for perjury and lying to federal officers. And in his grand jury testimony and statements to federal officers. So he had a law partner before he was a judge. And the partner asked Nixon, when he was a judge, to speak to another judge on behalf of his partner's son, who was up before him on charges. Nixon did so. He spoke to the other judge. The case was dropped, and word got out. When he was interviewed by the FBI and the Department of Justice, he lied. He denied any involvement. He also denied this to the grand jury. He lied to the grand jury. And in 1986, he was convicted by a court on 2 counts of perjury and sentenced to 5 years of prison on each count. He went to jail, he refused to resign, and he was collecting his salary while he was in the can. So the House impeached him in 1989, 417 to nothing. And this guy, and he appealed this impeachment from jail to the Supreme Court, and the court said they couldn't hear it because it was a non-justiciable political question. So that went to the question of, can impeachments be appealed? I think the answer is no, they can't. So that was one case with Nixon, with Judge Nixon. Then there was a judge whose name was Harry Claiborne, who was impeached, convicted, and removed for making false statements and filing tax returns that were phony. And filing tax returns, as you know, is a felony offense. Claiborne claimed that he was a victim of a mass conspiracy. I think we'll probably hear that. Overzealous prosecutors, illegal burglary of his home, perjured testimony from a criminal. We're going to hear that. But the court ruled all of that may or may not be true, but you engaged in impeachable conduct. And so he served 17 months of a 2-year sentence in -- and in '86 he was removed. Now, for impeachment, there are 2 steps. As we know, the House impeaches, the Senate tries, and if you're convicted, you lose your office. But there's another step. You can also be convicted and be ineligible to hold any other federal office. That's a separate count. And that hasn't been used very often. And it's interesting. There have been a number of judges. There's a guy named L.C. Hastings from Florida, from actually Palm Beach County, who was convicted. He was impeached, excuse me. He was impeached back in the late 80s, and he was kicked out of the House of Representatives. And he ran for Congress, and he's still there. 26 years later, he's still in Congress. So he did not, Congress could have, or they thought about it maybe, they could have prevented him from running for a federal office, but they did not, and he's still there. So it can happen. It can happen.
So he was tried by the Senate and convicted?
Yes. He was,
but not disqualified from holding.
That's correct, but not disqualified. That's correct. So, I wanted to
Who is it?
I thought I said L.C. Hastings. A-L-C-E-E. Hastings is his name. And he is from Palm Beach County. And he's held that, as I say, he's held that seat for many years. So as we move forward through this, basically we have to understand impeachment is a political process. It has nothing to do, or little to do, with criminal proceedings. You don't have to have committed a criminal act to be impeached, and if you have committed a criminal act, it doesn't mean that you should be impeached. The argument is that there are various kinds of criminal acts. There's fraud, or failing to file your income tax returns, or a whole bunch of these white-collar crime kinds of things that are felonies. And then you've got what may be called private crimes, crimes against the person, assault, battery, libel, slander, murder. They range. So every person will have a different opinion, perhaps, of whether one crime or another is something that is impeachable. Is this an impeachable offense? But I would argue that what really I think should be impeachable is not a single act or two, or maybe even three, but rather a pattern of conduct over a period of time that would demonstrate that the person in question, let's move away from the federal judges for a moment and talk about a president, that would demonstrate that a president has not been faithful to the execution of his duties, has not upheld the laws, etc. That kind of thing. So I think that's what would make most sense. And if you look at the impeachment, the listing of the offenses of impeachments for Nixon and Clinton, you will find, yes, you'll find obstruction of justice. Yes, you'll find some of these phrases that we continue to hear. But I think what you would also see is this pattern of conduct that where the individuals in question were deemed to have basically neglected their duties as president. Yes, Dave.
But in the cases that you cited, the focus seems to be exclusively on criminal acts.
Well, look, you're talking about the federal judges.
Well, you can throw Clinton and Nixon into it as well. So obstruction's a crime, and lying is a crime.
Well, that's true, but there were a whole list of other things. I don't think, I mean, what if you look at I mean, the Nixon thing started, with the break-in, at Watergate, and wound its way through, a couple of years of events, which, with the tapes and all of that other. So there's a whole panoply of activities, absolutely, lying, obstruction of justice. But I think there's a whole series of other things that I think if it had been limited to those two things, I'm not saying it wouldn't have wound up the same way, but there were other things. And in the Clinton case, where, this whole investigation started with Whitewater. And basically, what's his name, who was the special prosecutor? Ken Starr basically had kicked the Whitewater thing out the door, and 4 weeks later there was a phone call from a lady who said she had tapes of Monica Lewinsky. Well, I mean, that came out of nowhere. So that became a whole new process and investigation. So, was what he did criminal, or was it just, in poor taste?
But it seems it takes a specific criminal act, lying, or to trigger the feelings that all the rest of this stuff. So we come to this question. Let's just raise it. We'll take a short break and then come back and address it. This question of, remember, there's impeachment and then there's indictment. These are two very different things. Should the president be impeached for this? The question is one question, could he? I suggest that you need to also ask the question, should he? Because this is a political question. Do we do more damage to the system by impeaching the president? Well, again, it depends on whose side you're on and what you think and where you are in the process. But the indictment piece, is there a crime that has been committed? And that's presumably easier to determine. Yeah.
All of the discussion that's ongoing now basically dismisses collusion as being an issue, and that it would, even if it went to an impeachment hearing, it wouldn't hold up, that the obstruction issues are the ones that would hold up.
Yeah, I think we said earlier, collusion isn't really relevant. There's no crime of collusion. There's a crime of conspiracy. There's no crime of collusion. That doesn't exist in the law. It only exists in antitrust law, which maybe is criminal. But it's a different kind of law. So the collusion is, in my view, is out of the game. But conspiracy is possible. And we can argue all day about the difference between conspiracy and collusion. But yes, Mike.
What was Johnson, was he accused of?
President Johnson was basically a violation of the War Act. And it was, frankly, he was hated, widely hated. It was basically a personal vendetta. He had fired the Secretary of War. They were mad about that. It was right after the war was over. They thought he was going to be much tougher on amnesty than Lincoln was. It turned out that he wasn't. He was also, well, he was also drunk most of the time. No, but I think that kind of underlaid the whole thing. But you know, he missed being impeached by one vote. I mean, it was very close. So let's take 5 minutes and then come back. We'll come back to this indictment versus impeachment thing, because I think this is an interesting and important question. With all of these interesting things to debate, I don't know why these guys in Washington can't get together. It seems to me that there are some worthwhile decisions to be made. One of the things we haven't mentioned, I don't want to spend much time, but I want to mention it, is that there is another option beside impeachment, and that is the censure, which of course doesn't have any necessarily long-term impact or effect, but senators and congressmen have been censured over the years. I can remember in Massachusetts, back in the 70s, when we had 2 congressmen who were censured, essentially for similar activities with congressional pages, both Gary Studs and Barney Franks. It didn't seem to hurt their careers. At the time, there was a lot of talk and a book. Joe McCarthy was censured, and it did hurt his career. He really fell off the table. Yeah, he was pretty much after that happened, and his own personal behavior was definitely a part of that. But theoretically, the president could be censured. You know, would that have any effect on this president? I leave that to you. Yeah, I think maybe fake news. So we have this. Remember, we had this question earlier about the differentiation between official and private misconduct. It's arguable, I think, that Clinton and Monica, that was really private misconduct. I don't think he was engaged in official duties. I don't know. I wasn't there.
Multitasking.
But, okay. So thank you, Martha. So impeachable conduct doesn't have to occur in the course of performance of official duties. Evidence can be justified in one's private dealings. And on Clinton's, during his impeachment proceedings as they went on, it moved from, their position changed. It moved from they can't impeach on private conduct, which was their original position, to they could impeach, but these particular crimes did not merit impeachment. That's a different position. So they moved during the course of the proceedings from the former to the latter. So again, not all presidential misconduct is sufficient for impeachment. I think substantiality is an important term here. You consider the facts as a whole in the context of the office, the person, the events. Impeachment is predicated only upon the conduct of seriously incompatible with either the constitutional form of government or the principles of our government. And so one of the important positions that are taken, that have been taken by the court in talking about impeachment, is that, or in talking about indictment, excuse me, not impeachment, indictment, is that you shouldn't indict a president while he's in office because he's the president and because he is in charge of the executive office, and basically because he's so important. You know, he's got so much to do. And during the impeachment of, not impeachment, during Agnew was not impeached, he resigned after he was indicted. But there was a question about whether he could be indicted as vice president. And Robert Bork, who was the Solicitor General, argued for the government that the vice president could be indicted while he was vice president, because after all, he was the vice president. You know, basically chop liver. Let's not worry about him. But he said the president is a different story. So I just wonder, I don't know how many of you saw it, in the last couple of weeks, somebody had the typical day of the current president, which runs from the typical day, you know, from 8 to 4, ran something, as I recall, like this. From 8 to 11, he has executive time, whatever that is. He's somewhere in his room. From 11 to 12, well, from 11, at 11, he has a meeting with General Kelly. It's not sure how long that meeting lasts. I think the way things are going now, it doesn't last too long. And then when he's finished with that meeting, until noon, he has executive time. Then he has lunch from 12 to 1. Then he has another hour of executive time. I'm not making this up. Then at 2 o'clock, he has a meeting scheduled with General McMaster. I don't know how long that meeting lasts. But at 3 o'clock, he has a half hour of executive time. And then he has a meeting with Johnny DeStefano. Who's going to tell me who is Johnny DeStefano? Whoa! I thought maybe his bookie, I have not. Johnny DeStefano is a guy who is in charge of White House personnel, obviously doing a wonderful job. And he worked, his claim to fame was that he worked for Speaker Boehner for 6 or 7 years. And apparently when Boehner went to Florida, this young man did not go with him. And so he has become the chief of White House personnel. So, and then after that, he's finished for the day. So basically, 6 hours of the day is executive time, and he's in meetings maybe 2 hours, and he's working very hard. So are these activities such that, you know, we can argue legitimately, or argue anyway at all, that the position of the president is so important that he can't be indicted? And why is that? The argument goes, is that if he's indicted, he would have to spend so much time responding and being involved in the indictment that he would have to neglect his duties as President of the United States. So I'm taking, these words are not exactly quotes, but this is the argument that is basically a strong argument about why there are some constitutionalists who say the president cannot be indicted while he's president. He can be indicted, they would argue, after he was president. Now, in the last 20 years, maybe a little more, there have been 4 or 5 Office of Legal Counsel, OLC memoranda within the Justice Department on this very point. Can a sitting president be indicted? And the answers have been mixed, but more of these memos than not say he can't be indicted. Basically, for the reason that I have suggested to you, a recent memo which nobody had seen was written in 1988, I think, and it hadn't seen the light of day. I'm not sure how it was buried, but somebody found it, and it came to an opposite conclusion. It said a sitting president could be indicted. And I think it was written during the Clinton administration. But it went on to say, maybe he couldn't be, if he was convicted, maybe he couldn't be imprisoned during that time if he was convicted of whatever crime we're talking about. Now remember, in Massachusetts, we had a guy who was mayor who went to federal prison. I guess it wouldn't be nice if we had a president who was in a federal prison. I think that would, I think our standing in the world would be slightly impacted. But my point is, this issue is unresolved. And the courts actually have never addressed it. So we have another very interesting situation. Yes, Dave.
Does it take less time to prepare for an indictment than it does for an impeachment?
Well, I think that's a very fair question. And I think certain people who have discussed this point have raised that very question. I think they would argue, I think what I've seen is, you know, the impeachment, he's not basically involved in the discussions. You know, he's not there. Whereas in a criminal trial, you know, you've got the question of whether, for example, whether he would have to appear. You know, can the president be, this is another question that's never been answered. They've testified, excuse me, as I've said, in criminal trials, mostly by videotape, although they've given depositions. I don't think a president has ever appeared in a courtroom in a criminal trial, but in his own case, he would have to appear in a courtroom or on a videotape because he'd have a right to testify. I mean, you know, he certainly is entitled to that. So, but I think your point is a good one. And if you look at the constitutional scholars on both sides of this issue, you know, you toss the paper on one hand and the paper on another. The fact is that it's pretty even. My view is that, for whatever it's worth, is that the better arguments are on the side of those who say that he could be indicted. I think if the crime is sufficient, this argument that, you know, he's too important as the CEO, you know, you might argue back in the days of Washington and Adams and I mean, the federal government was, you know, sitting in this room. Now you've got hundreds of thousands of people all over the country, all over the world, and he hasn't got the vaguest idea what's happening. So why should that be an impediment to the indictment? If there's a constitutional reason, I think maybe you can raise that question. So anyway, that's my take. So let's talk for a minute about the possibility of impeachment after resignation. And several people said to me, why would you want to impeach anybody after they're out?
You can't impeach him, he's gone.
Well, it's interesting. Article 2 says, we looked at it earlier, Article 2's inclusion of all civil offices raises the question whether the resignation of an impeachable officer precludes the initiation or continuation of an impeachment. Congress has never conducted a successful impeachment against somebody after resignation, but there's a surprising consensus among commentators that resignation does not preclude impeachment and disqualification. First of all, back in the Old English days, impeachment was not limited to officials still in office. During the Constitutional Convention back in the 1780s, several states allowed impeachment after their officials have left office. I believe today in Vermont that the Constitution permits impeachment after the officials
But what happens?
have left. They're impeached.
But
They don't lose it.
They're impeached.
it's just a mark on their.
It is. Or they can be disqualified from further office, if you'd like to do that. So I think that here's an interesting comment by John Quincy Adams. Remember, he's the only president who ever went back and served in Congress. He was elected as a congressman. This is a quote. "I hold myself, so long as I have the breath of life in my body, amenable to impeachment by this House for everything I did during the time I held the presidency." So that's from John Quincy Adams, who was president. We don't have those kinds of people hanging around anymore. And so again, you know, this is an interesting question. I don't know. One might argue that if you didn't have a successful this issue of indictment and impeachment, if you didn't impeach the person during the course of his presidency but went for an indictment, if the indictment wasn't successful, would it make sense? I think the answer is, I don't know. Depends on the circumstances. Is it worth the time, the effort, the money, the heartache? You know, maybe people would rather say good riddance, but I think it's kind of an unknown thing. So.
So Nixon could run again because he left before they could have indicted him.
Well, I don't believe, I would have to look, but I don't believe that the pardon, or that the impeachment, excuse me, and he was pardoned. So I don't believe, remember, he wasn't impeached.
That's right.
So he was pardoned.
Right.
And he was pardoned for all crimes that he, so I think theoretically he might have actually been able to. But clearly, what's that? Yeah, absolutely. He's running. And we know that this guy, Alcee Hastings, has served 13 times in Congress after being impeached as a federal judge. So it does happen. It does happen. The system is indeed a strange one. Marty?
Do you have any recollection of what was the source of the justification of his impeachment as a federal judge?
Hastings? Yeah, no, it was, I think it was bribery and land deals, I think, in Florida. I think it was a long process. And it went on for some years. He was a very young man. He's a very attractive, personable candidate. I mean, you're not elected 13 terms in Palm Beach County if you're not. He was able to overcome it. So So as I look at Thursday, I think we'll have a brief review of where we've been today. I want to talk a bit. I've sent you just a little material on the rule of law, which I think is a very important concept that kind of gets tossed aside. I'm not sure that many people have a real feeling for what this is. And I think we'll have some time to talk about whether this pardon power is something that we can, quote unquote, do anything about, or whether we need to live with what it is, and what impact, if any, we think it'll have going forward. Obviously, any questions that you've collected over these first 3 classes, we'll do our best to answer, and we'll wrap it up. So I thank you very much.